Hello. Hi, VC. Hello. Good to see you. Welcome, welcome, welcome. Yes, I'm doing well. I'm doing very well. Thank you. Hopefully, you are also having a good day. Hopefully, it is Wednesday, so not Monday, so that's always good. Yes, yes. Hello again. Hello again. I was excited we were able to go through Aloha. We were able to go through the subpoena request. Yes. Oh, VC, I tell you, oh my gosh, I really need to take a class or something. I'm struggling. I, I could not figure out how to get my computer to work well enough. So I was afraid I wouldn't be able to see the comments because I have to set up my comment section different. So closer to Friday afternoon. I agree. Yes, so I've got, once my computer is recovered, we'll be able to do it. Yes. Yeah, my hand is actually doing much better. It is much better. So I'm very thankful for that. But my computer, on the other hand, is not. Not yet. Soon, though. Well, hello, Kristen. Welcome back. So I'm. Oh my gosh, I've got, I'm not good with the technology. I try, but try and fail. That's all right. But I'll get there next week. I am determined to go once a week for sure on the tube of you. So I do plan to do that. So I think by next week I should have, I should have things. What'd you do to your hand? Oh, yeah, I had my brace off. I'm very excited, everybody. Hopefully you can't see the bruising. I'll try to cover the bruising up a little bit. Yes, so I had was had a unfortunate accident and in the middle of the night without realizing it, and my hand accidentally punched my computer accidentally. I didn't know I was doing it. So I had it in a brace. I should probably still have it in a brace, but it's out of the brace for tonight. No knives were involved. It's a little swollen. The color's gone down, and I was able to get this ring on yesterday, so I thought that was a good sign. But yeah, it's just one of those things, unfortunately. But it's definitely better. It's definitely better. So the first, right after it had happened, when I had woken up, I had gone in and it's gone down a lot. Yeah, it certainly has. But when I went into my doctor, I just didn't have a really good excuse. Like, what happened? Like, it's not a good story. It's not, it's just not. So, but yes, it's getting better. The bruising is definitely getting better. So, yeah, it's a little bit of poor both. I did. I felt, oh my gosh. Yes. So everything's been moved away from the bed now. So when I'm sleeping, oh my goodness. Really? Okay. Arnica cream. Really? It does look better. Yes. If you're beating your computer. Yes. I really was. Oh my goodness. I know. I know. Yeah, it was a lot. But that's all right. My mom was not impressed. I think out of everybody, my mom just rolled her eyes the hardest. She's like, "What?" Okay, definitely. I'll have to look into that. Put some of that on. It's doing a lot better. I'm just a lot. I'm not sure. I'm not sure if it was a jab or an uppercut. But my thumb was out. So that was my, as long as your thumb stays out, right, and doesn't go in. So I felt like that was a win. Punch you while you're asleep. Oh my goodness. Well, I know there can be some significant kicking involved with your partner, but oh my gosh. Yeah, punching is usually, and I'm just not a punchy person. So it's not, It's not really in my nature. So it was a very odd set of facts going on there. Very odd situation. But so apparently I was on a medication that apparently makes you punchy. Oh my gosh. Yeah, so it was just this medication that that I was on. And it can give you like really like vivid bad night terrors. And so I was just having a really bad dream. So night tremors. Yes. Okay, tremors or terrors, because both of those are bad. Sleepwalk. Oh, yes. Oh my gosh. Got to make a careful path for yourself. But yeah, I had there was someone who was attacked with both. No terrors. Oh, thank goodness. Yeah, I was being attacked because somebody had taken a car engine out of the car. It was coming after me with a car engine. Like, that's not a chosen weapon of choice. But that could be election issues. Could be. I don't know why. It was the car engine. Yeah, it made me a little punchy. So, oh my gosh. Yeah, there wasn't much logic. It was really ridiculous. Really ridiculous. Oh my gosh, Suze, no. You can't put it was a car engine. Yeah. And I was like, how can you hold a car engine? And it was like he was going to hit me with it. It was crazy. Yeah, it was really, yeah. So the medication, my doctor's like, you need to go off of that. And I did. And, I have to admit, I feel much better now. So I'm doing a lot better. Oh my gosh. A Fiat, not a Cadillac. That's so funny. Oh my gosh. I defended myself. Yeah, I have I don't think that would be a problem. But, as long as other people, as my husband's safe, he's safe. He's safe. He's very safe. Really? Because he was dreaming she was about to, oh no, he was trying to protect her, push her out of the way. Oh my gosh. Oh, that's so sweet. No, my husband's understanding. And actually okay, so just between us, as everyone's kind of joining right now, but so very early on when we were first together, I didn't really talk in my sleep, but I made these weird sounds when I was sleeping. And I asked him, I'm like, what do you mean I make sounds? He's like, it's like you're yodeling. I'm like, are you telling me I yodel in my sleep? And he's like, yes, it's so weird. So he's used to weird stuff. He's used to it. It's, he says it's part of my charm. Oh my gosh. Yes, yodeling. I know, right? I don't know what happens. I'm not sure if it's like an actual yodel, but that's what he said it sounded like. And I said, I don't know. If you can't get it recorded, I'm not sure I believe you. And he's like, whatever, I don't care. No, there's snoring too. But yes, swing and strangle. No strangling. I'm a big talker. Oh my gosh, that's so funny. Pulling your pillows. Oh, that's hardcore. That's really hardcore. Oh my goodness. Yes. Well, we couldn't watch The Sound of Music after that. So yes. Everybody made it out okay. The significant other is fully aware of my shortcomings. It would make a great TikTok. I don't know. That's pretty ridiculous. Yes, yes. Well, he's odd too. So we're both strange people. Oh my gosh. Yes, go for that, Frank. Go for it. I agree. Yeah, no, he's got his little quirks about him too. So he's very the punching yodeler. Oh my gosh. I've said too much. Oh my goodness. All right. Well, welcome back, everybody. Welcome back. I was on a little bit earlier tonight, just as a quick bonus. We were going through the request for subpoenas that Hunter Biden had put out. So he had requested some subpoenas for documentation. So we kind of went through that earlier real quick. Chipmunky. Oh, that's interesting. Oh, very. Yes. So, but tonight's live, I had planned to live stream on my Tube of You channel, but I had some technical problems. So, so I'm back here. But I will, I'm going to try in the future to be on my Tube of You channel on Wednesdays. So it is very fun over there. I just need to, I need to get a few things fixed first, and then I will. Oh my gosh. Yes, I know. I'll be back over there for sure. Oh my gosh. Yes, the laptop. Yes, it's not happy. So tonight, everybody, I would like to go through this code of conduct that the U.S. Supreme Court has set out. So very controversial. SCOTUS is very controversial, and I don't have a lot of sympathy. They did it to themselves in this situation. If you ever do get a chance, of course, the Dobbs case is what overruled Roe v. Wade and the Casey v. Planned Parenthood case now on reproductive rights. So if you do get a chance to take a look at the Dobbs case, I highly recommend the dissent, because in Justice Sotomayor's dissent, she set out how the American public was going to respond. And I think it was very accurate. She had said, I don't think they're going to forgive us. And I think the legitimacy of the Supreme Court will always be in question now. And I think it's very accurate. So she did an amazing dissent on that case. So she was on fire. You could feel how upset she was about the case for sure. So yes. So here we go. Regarding the code of conduct, so the Supreme Court's never had this before. They've used kind of rough rules that the federal court judges use. They've got a code of conduct, but it's never been specific to the Supreme Court. They've never required that on there. Yes, Sotomayor, she's amazing. She's an amazing justice. So they did decide to go ahead and put up some rules. Now, there's a couple of things to note. First, there's kind of this introductory paragraph that they start with to kind of explain why they're even doing a code of conduct. Then we'll get into the primary canons, which explain the financial disclosures and things like that. And then there is a commentary. Now, I'm not actually going to go through the full commentary at this point. I may do another live on it, but the commentary I don't think is necessarily as interesting as the actual rules themselves. So I will take you through their rules here. But, one of the things that a lot of people are saying is, well, how does it get enforced? And, that's a really valid question. Our entire field, the legal field, we are kind of on an honor system. We regulate ourselves. So we're a self-regulating industry. So it's a group of attorneys that make sure all of us are ethical. It's a board of attorneys that get called in to judge and make sure other attorneys, if they lose their license, it's time and so on. So we have a lot of self-governing rules. Now, I think it's really interesting here once we take a look at these rules, because this is going to be self-governing. But you've got 9 justices here, so 9 individuals, and it's their goal to monitor each other. Now, some people may say, well, then what's going to happen then? They can't, who's going to enforce the rules? They enforce the rules on each other. That may not seem like a lot, but when you've got 9 justices, the highest level of law in the country, and again, I would remind you, and even starting out talking about that dissent in the Dobbs case, these justices, they're not playing around. Justice Sotomayor, she will go up to the Chief Justice and be like, you're out of line when he's out of line. And the other justices do that as well. So there have been a lot of back and forth between the justices. So if there are ethics violations, again, at least we now have a starting point, and I think that's a really good place, again, to begin. Never had anything like this before. It's a start. It's just a start. So Will there be more? I hope so. Will there be other mechanisms put into place? Yes, I hope so. But again, we're just starting. At least it's a beginning. When all of this started, a year, 2 years ago, the Chief Justice had said, no, we're not going to have any code of conduct whatsoever. And now they've come back in and they've all agreed to a code of conduct. So at least we've got something started. So let me take you through here what we've got. So again, all 9 justices agreed to this. All the justices that come in will need to agree to these as well. So here we go. Statement of the court regarding the code of conduct. And I do have a sticky note, so I will put that on once we flip the page here. So the undersigned justices are promulgating this code of conduct to set out succinctly and gather in one place the ethics, rules, and principles that guide the conduct of the members of the court. For the most part, these rules and principles are not new. The court has long had the equivalent of common law ethics rules, that is, a body of rules derived from a variety of sources, including statutory provisions, the code that applies to other members of the federal judiciary, ethics advisory opinions issued by the Judicial Conference Committee on Codes of Conduct, and historic practice. The absence of a code, however, has led in recent years to the misunderstanding that the justices of this court, unlike all other jurists in this country, regard themselves as unrestricted by any ethics rules. I believe they wrote it all together. We don't know which judge actually wrote it themselves, but I think they all contributed. So to dispel this misunderstanding, we are issuing this code, which largely represents the codification of principles that we have long regarded as governing our conduct, and then set out November 13th. So again, very interesting here that they're not saying, we're putting this code in order to make sure that we are above reproach. They're saying, no, you all misunderstand us. So let's set this code out. Exactly, Jim. That's exactly right. So, let's put this together. Again, my sympathy is next to zero because this is the path that they took. So let's go ahead and go through some of these rules then that they've set out. All right, so Code of Conduct for Justices of the Supreme Court of the United States. Canon 1, a justice should uphold the integrity and independence of the judiciary. A justice of the Supreme Court of the United States should maintain and observe high standards of conduct in order to preserve the integrity and independence of the federal judiciary. Sticky note, thank you, Frank. I was right here, I was waiting for it. So that's the first canon. Language is very similar to all of the rest of us for our ethics rules. So integrity and independence of the judiciary. Canon number 2. A justice should avoid impropriety and the appearance of impropriety in all activities. So now that is a really important piece. They're going to kind of break this down into 3 different sections. So yes, that language, a justice should, is how our ethics are written. A justice should, or an attorney should, or a federal judge should. That's just very typical language that we use. A is respect for law. The justice should respect and comply with the law and act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. Now, again, what does that mean? That's a lot of how our ethics are written. B, outside influence. A justice should not allow family, social, political, financial, or other relationships to influence official conduct or judgment. A justice should neither knowingly lend the prestige of the judicial office to advance the private interests of the justice or others, nor knowingly convey or permit others to convey the impression that they are in a special position to influence the justices. A justice should not testify voluntarily as a character witness. So I think, again, these are all important pieces that really needed to be said, particularly regarding Thomas. Absolutely. So I think that clarification was really important. And also this idea of testifying, I think that's important. So you can ask if you need a character witness. So if you're in trouble, sometimes you can offer evidence saying, I've got a really good character, so, let the consequences not be so bad for me. For example, let's just say if there was a criminal case where a former president was convicted, all right, he could present character witnesses, or he could present affidavits or statements from people to the judge in order to impact the kind of sentence the judge would do. So the sentencing judge. So what they're saying here is that a justice on the Supreme Court is not allowed to come in and testify as a character witness for that former president. I'm just saying. I'm just putting that out there. I'm not mentioning any names, but they're not allowed to do that because, of course, the assumption is if a Supreme Court justice is coming and helping you out as a character witness, then you must have very good character. That's undue influence. If you have a case of involuntary being a character witness, do you have a case? No, I don't. Felony. Yeah, I mean, it's just kind of those situations. Can they write a letter? No, that would be also considered testimony. So any kind of a situation where someone is asking for the opinion of a justice on a character, and they are in the realm of basically saying this particular person's okay, they're not allowed to do that because that would be seen as inappropriate. And a certain spouse of justice. Yeah. Well, now spouses aren't included yet, so I'm not sure about the spouse element, but we will see. Should not or can't. Okay. So the way that our ethics rules are written, everybody, are the simplest of words like must, should, have to, any of those things, or may, or is allowed, those kinds of words. We would use the term should when it comes to our ethics. So we don't use a must because it just, or requirement, those kinds of words have different meanings for us. So when we have our ethics rules set out, we use the term should. A lawyer should always whatever, or a lawyer should recuse themselves if there's a conflict of interest. So this word should is something that we use in the industry. Family's not a spouse, could be. Shall, may implies to the best of the ability. Yes, right. So again, I think this is just our language that we use as what we do when we're talking about our ethics. This is very typical language. Has any teeth? Yeah, it's a good question. So let me just, I've got my the American Bar Association rules of conduct. Let me just give you an example to show you some of that language that they use. Just to let you know here, come on, computer, be my buddy. So, we'll just pick out a random rule here. All right. Okay. Here we go. Okay, so client-lawyer relationship, a lawyer shall not make an agreement for change or for charge or collect an unreasonable fee for an unreasonable amount of expenses. The factors to be considered in determining a reasonable fee are the following. So again, I'm just picking out random rules here. The scope of the representation and basis of or rate and so on. Let me look through here. I'm trying to find client will be responsible, shall be communicated to the client. Hold on just a second, everybody. I'm looking for a should. Uh-oh. I hope we have a should in there. Shall be, yes. Let's look. Let's check another one here. A lawyer shall hold property of clients. A lawyer may deposit. A lawyer shall deposit. A lawyer shall promptly notify when in the course. A lawyer's in possession. The claims property shall be kept. Well, that's interesting. Okay, hold on. Just a minute here, everyone. Okay, so I'm looking at my state rules. I'm just checking my state code of ethics here. Yeah, determining a lawyer's authority and responsibilities. Principles, right? So let me pull up a random rule. Wow, we have a lot of rules, everybody. We have a lot of rules. I'm scrolling on my little green screen here. Okay. Or it performs various functions. May serve. May, should be. Okay, here it is. Right. Functions a lawyer should be. Lawyer's conduct should conform. A public citizen, a lawyer should seek. Okay, so according to my state rules, we're using the term should. Just to clarify, all right? Shall is definitely stronger, but according to my state rules that I'm looking at for my rules of professional conduct, we are using the word should. I was going to say, I didn't think I just made that up out of nowhere. So should be responsibilities, an officer, and so on. What would family and other relationships include? All right, so let's take a step back. Okay, so everybody, just so you know, it looks like shall is being used by the ABA. And again, remember the ABA is the American Bar Association. Those are suggestions. Those are not the actual language. Now, according to my state rules, we do use the word should repeatedly. Have to do is mandatory. I don't think it should be. Okay. So, should not allow family, social, political, financial, or other relationships to influence official conduct or judgment. So family, the legal terminology for family would be anyone that would inherit. So that could be your spouse, or it could be your children, or it could be your parents. So that would be family. And it's such a general term the way it's used here. I think it could include any of your relatives along with your spouse. I think that would definitely be included. So again, I'm just double checking let me pull up real quick. Let me pull up the federal judges. Let me see here. I've got, whoopsies. Sorry, everybody. My computer is being held together with duct tape. So, all right. Let me just pull up a couple of their rules here, just to see if they've got should in there as well. I think that's a great question. I think that's a really great question. So let's take a look, pull up their rules. I've got the federal judges rules here. Code of conduct for judicial employees. Expected to observe high standards of conduct, so the integrity and independence of the judiciary are preserved. So let's take a look real quick, and let me see if I can give you an example. I'm just interested if they say should or if they say shall. I think that's really a valid question. So let's take a look here. Okay. Judges are subject to the Code of Conduct for the United States Judges. Volume 2A. So let me take a look real quick, and then we'll jump back in. Subject to ethics. Okay, scrolling. Okay, yeah. A judicial employee should uphold the integrity and independence of the judiciary and of the judicial employee's office. should avoid impropriety and the appearance of impropriety in all activities. Canon 2, should adhere to appropriate standards in performing the duties of the office. Okay, so I think we're there. So the American Bar Association has a shall in there, but the federal judiciary ethics says should, and my own state says should as well. So I'm just clarifying that for everybody. All right, where was I? Yes, but that's interesting because I never felt, the state rules that I'm looking at for my own professional code of ethics, I would never have thought should was optional. Should is not an optional piece of our ethics. But, I think that's a great point. Lexi, I'm not sure. I'm not really sure what the difference is. That's the language that I have been familiar with. So, I'm not sure, but I think it's a valid question. Can we score, Thomas? We'll see. Yeah, we'll see. For how our canons are set out too. The other thing is when we're doing codes of conduct, we set out canons rather than setting out rules like we would for statutes. So language is a little bit different, but let's dive back in. The should, don't get too caught up in the should. These are required. So make no mistake, when there is a code of conduct, this is required rules here. Okay, no red pen. All right, let's jump back in. Okay, C, non-discriminatory membership. This would have been huge back in the 40s and 50s. Wow, there was some rampant issues with that going on. A justice should not hold membership in any organization that practices invidious discrimination on the basis of race, sex, religion, or national origin. This is important because in the past we have had a couple justices who were part of the Klan. So we don't like that at all. So that's interesting. And so that's the second canon. Should implies you don't have to. Shall implies you will. Yes, but I just not on a legal level. If you have a statute with a should in it, I don't know. Let me look into it. Should versus shall. I think that's such an interesting question, everybody. It hadn't really crossed my mind. I think it's just a very valid question. All right, so nobody can be part of these kinds in any organization that practices discrimination on the basis of race, sex, religion, or national origin. Yes, so definitely. Canon 3, a justice should perform the duties of office fairly, impartially, impartially, and diligently. So here are our responsibilities. He's supposed to, but he didn't. Yeah, it sounds too discretionary. Yeah, I think you have valid points. I will need to look into that a little bit further. A, responsibilities. The justice should not be swayed. So again, there's that should in there. I should go to the gym. I shall go to the gym. Language is so important, isn't it? I know. Shall not be swayed by partisan interests, public clamor, or fear of criticism. All right. A justice should participate in matters assigned unless disqualified and should maintain order and decorum in judicial proceedings. So I guess they can't threaten to hit each other, unlike some parts of government. A justice should be patient, dignified, respectful, and courteous to all individuals with whom the justice deals in an official capacity. So, that doesn't happen during oral arguments. That would have been a ding against Scalia. I'm just putting that out there. So they can be part of an well, it looks like that's not one of the protected classes that they've mentioned here. It's very controversial. A justice should not engage in behavior that's harassing, abusive, prejudiced, or biased. A justice should not retaliate against those who report misconduct. So this will be our first sentence that's addressing what happens if someone calls them out. A justice should require similar conduct by those subject to the justice's control. So like their clerks. Can you slide the paper to the left? Sure. It looks like it's in frame to me, but let me move it. Let me make sure. There we go. Yep. How's that? Oh, I love it. I love it. I think it's great. Good. Okay. Good, good, good. All right. Love it. All right. Here we go. A justice should take appropriate action upon receipt of reliable information indicating the likelihood of misconduct by a court employee. So that's another piece saying what happens if someone is behaving incorrectly. So we've got one here. Here's another one. Except as provided by law or court rule, a justice should not initiate, permit, or consider ex parte communications. Ex parte means one side but not the other. So ex parte is allowable in certain situations, but here they're saying they're not allowed to consider ex parte communications, which makes sense as SCOTUS, or consider other communications concerning a pending or impending matter that are made outside the presence of the parties and their lawyers. That's just also very appropriate. If a justice receives an unauthorized ex parte communication bearing on the substance of the matter, the justice should promptly notify the parties of the subject matter of the communication. And allow the parties to respond. A justice should not knowingly make public comment on the merits of a matter pending or impending in any court. And this is one of those unspoken rules that has finally been put down. So that's good. The prohibition on public comment on the merits of matter does not extend to public statements made in the course of the justice's official duties. All right, so this is a clarification probably with regards specifically to Justice Alito, who did an op-ed article in the Wall Street Journal, I think. Pending versus impending. Yes. So if it's in front of them right now or it's on the way. it's on the way. Or this week, this session, or maybe in the next year or so, because they have such a huge amount of notice typically before they see their cases. All right, so for scholarly, informational, or educational purposes, a justice may describe the issues in a pending or impending case. So this basically just says this is a catch-all, because anything that's scholarly, informational, or educational, that can be anything. So they basically said you can't make these statements unless it's for educational purposes. So I think we all know what that means, right? A justice should require similar restraint by court personnel subject to the justice's control. A justice should not direct court personnel to engage in conduct on the justice's behalf or as the justice's representatives when the conduct would contravene the canons if undertaken by the justice. So this just means anyone that works for them is subject to the same rules that they are subject to, which is a typical how we do word a lot of our ethics. Employees, yeah, you can do this, you can't do that. Yeah, that would be good. Who decides if the ethics code is violated and who enforces it? Right. So let me give you an example. All right. So if as an attorney here in my jurisdiction, in my state, if I see another attorney do something, or if anybody sees another attorney do something that's unethical, I have to report them. I have to. If I think that there's a violation of an ethics code, it would be a violation of my own ethics to not report it. So I've got to report it. So that's what's going to happen here. If anyone sees a violation, they have to report it. So they're looking through all of these rules. Someone has done it. They will need to report it. I'm assuming they will report it to the Chief Justice. So John Roberts would be the one that would be told about it, and then they would go forward. How they enforce it will be up to them. I think that you've got a group of 9 people with equal power in this set of circumstances, and so they will need to sit and decide how they're going to deal with the ethics violation. I reported to the Bar Association. Right. See, they don't have anything like that. We have in my state, we have a committee and an organization that monitors attorneys' ethics. There is no organization that is high enough that can monitor the Supreme Court, the U.S. Supreme Court, when it comes to ethics. Now, Technically, many would say Madison and Hamilton said it so that Congress would be the check for the Supreme Court. But the Supreme Court didn't have any power originally back when they designed the Constitution. So I'm not sure how exactly that's supposed to be going. Yeah, we monitor ourselves. But you have to keep in mind too, and I'm not going to defend any of this because it's just not possible. But you have to keep in mind too that, we as lawyers, we are the hall monitors. We were those hall monitors. We were those tattletales. We were the ones, narking on everybody else. Those people that did that, they are attorneys. And so we have no problem going and saying this attorney is out of line. We have no problem with that. That's, part of our wiring. That's how we are designed, most of us. I know that's a sweeping generality, but it's true. And that's one of the reasons why they kind of leave it to us to govern ourselves. We report to a group of lawyers, they report to a group of lawyers, and then everybody gets kind of called out to task. Need a Supreme Court playground supervisor. I would agree. Yes. The problem is, who would that be, though? I think that's really the issue, is that there is no way. Who would you get? Like a group of retired judges? I'm wondering about that. Like, can't we get some of our most respected judges to be part of the ethics overview committee? But then again, that would kind of take away the power of the Supreme Court. Now, Roberts is in charge of the ethics committee for all of the federal judges. He is the one in charge for all federal judges. All ethics complaints eventually will end up on his desk for federal judges. So we don't have anybody above him. He is the top dog. So I think, I'm not sure. We would have to figure out how we would get people. We don't want necessarily elected people in there because, we've got partisans. But if you've got judges who have been in the business and have had amazing careers and they're retiring, maybe they could do like 5 years voluntary ethics service to watch over the Supreme Court, and after 5 years it expires and then the next batch comes in and they can be nominated by their peers and approved by the Supreme Court itself. They can say, yes, we respect these judges. They've had great careers. We agree. And then we would have a panel then that could kind of watch out for things. But that's the question. Who watches out for Roberts? Exactly. That's the question. So it would have to be a group of people and they would have to be above reproach. Congress needs to set rules we do have rules. We do have very specific rules for impeaching us Supreme Court justices. Checks and balances are key. Absolutely. Absolutely. So it's very important, but that's my thought, is that if we could kind of somehow get a panel together, and it would be a rotating panel too, because also they've worked their entire lives as judges. They probably don't want to spend the last of their lives like having to review the Supreme Court, So who's above approach? Who's above reproach? It's a great question, but you can find some. I think that there could be some, I think that there could be some candidates out there, and then on a rotating basis as well, so that, no one is in that position for so long that they have too much power. And that's one of the issues with SCOTUS, is because it's lifetime appointment, which they need in order to do their job. And so I get it, but then it also can lead to this huge appearance of impropriety. Yes, yeah. It's the public that checks the court. It truly is. It truly is the public, everybody, because if it hadn't been everybody getting so upset about the reports coming out, they wouldn't have pulled in this code of conduct. They wouldn't have done it. So technically, in my humble opinion, it was the people. All right, so here's B for disqualification. So we've got a few different pieces set out here. And then we've got disqualification. So sub B, a justice is presumed impartial and has an obligation to sit unless disqualified. And that makes sense. Number 2, a justice should disqualify himself or herself in a proceeding in which the justice's impartiality might reasonably be questioned. So this is very typical language also. We have term limits of 8 years. Yes, I think these went into effect as soon as they came out. So this would have been just a couple days ago. That is where an unbiased and reasonable person who's aware of all relevant circumstances would doubt that the justice could fairly discharge his or her duties. So an unbiased and a reasonable person standard as opposed to a reasonable judge standard. So that's interesting. This is actually a lower standard. So that's good. That the justice could fairly discharge his or her duties. So would a reasonable person think the justice could not be unbiased in that situation? I think is really a great question. Such instances include, but are not limited to those in which, and then we've got some examples. Alito and Thomas, absolutely they do. That's, yeah, without a doubt. Okay, so here's some examples. A, the justice has personal bias or prejudice concerning a party or personal knowledge of disputed evidentiary facts concerning the proceeding. So that's just a given. B, at a prior stage in the proceeding, the justice represented a party or a lawyer with whom the justice previously practiced law, served during such association as a lawyer for a party, or the justice or lawyers has been a material witness in the proceeding. Okay, so I think this is really important. I want to give you an example. So a lot of you probably know of the United Citizens case, right? So that was a really big Citizens versus FCC. So the Federal Campaign Commission. My words are getting mixed up. Okay. Yes. Okay. So right, everyone's Citizens United. I've got my words flipped around. Citizens United case, which said it doesn't matter how much you donate to campaigns, it's okay. Everyone? Right? Okay. Would they ever admit to being biased? I think they would. So under this case, in the Citizens United, where the Supreme Court, some people say it's the worst case they've ever decided, or in a recent memory, I would agree with that. But in this case, they said unlimited campaign donations. Now, the attorney arguing for the government on this side of the case that was arguing against unlimited donations was Justice Kagan before she was justice. So she was the attorney representing the government on the Citizens United case. So for her, if any case came in front of her with this same kind of situation and the same people involved, she would have to step down because there would be a conflict. Are you following me on that one? So, that's an example. Yeah, she would have to step down. She would be disqualified because of that. So that's a pretty major case. I mean, that's a very significant case. But because we've got Gorsuch, we have Kavanaugh and Jackson Brown, who have just recently joined the bench, they're going to have a lot of open cases with other attorneys that they've worked on. So what they're saying here is that you need to step aside. Right. Okay. She should step down, but she shan't. I think she sheds. She shalt. She shalleth. Yeah, they have. But I mean, Thomas has been there forever. He hasn't had any cases that he's been on. John Roberts too. I mean, it's been a long time. So, I mean, I don't know. The most recent one, in my humble opinion, I'm not sure Alito should have been involved in the Dobbs case. All right. I know, controversial, but I said it. He was a dissenting circuit judge at the time for the Casey case, which Dobbs overruled. And I think he was a little bit upset about that. So in my humble opinion, I'm not sure he should have been on that one. All right. But that's just my opinion. So fair point here. Very fair point. The other thing, too, is if a justice isn't identifying, and I think Cozy had such a great question because, like, hey, who's going to admit that they're biased? But they've got 8 other people with equally strong egos and senses of right and wrong sitting next to them. So it really is their colleagues as well that are going to say, hey, I think there's a problem here, and then they can discuss it. And C, the justice knows that the justice individually or as a fiduciary, or the justice's spouse or minor child residing in the justice's household has a financial interest in the subject matter in controversy, or in a party to the proceeding, or any other interest that could be affected substantially by the outcome of the proceeding. So I think that's really important too. So justice's spouse, I think we know who we're talking about here, or any minor children residing in the home. So if anybody has a financial interest in the case, you have to take care of it. Yep. So that would lead to a disqualification. Keep in mind, again, they're just giving us examples of what a disqualification would be. All right, and here's D. The justice or the justice's spouse or a person related to either within the third degree of relationship. So that's interesting. It could be the spouse's brother or the spouse's brother's kid, or the spouse of such a person. So the spouse's brother's kid's spouse, oh my goodness, is known by the justice, 1, to be a party to the proceeding or an officer, director, or trustee of a party, 2, to be acting as a lawyer in the proceeding, 3, to have an interest that could be substantially affected by the outcome of the proceeding, or 4, likely to be a material witness in the proceeding. So we've got 3 degrees of relationships between the justice or the justice's spouse, or so 3 degrees, 6 degrees of oh my gosh, it sounds like a hot mess. I know it does sound like it, but it's pretty, this is actually this looks a lot like our code of ethics too, for conflicts of interest. So, if we are against opposing counsel and opposing counsel is our spouse, or the brother of our spouse, we have to be careful about, how we go about that. All right. So what counts as an interest? Well, I think if there is any kind of a loss or gain, you could see it as an interest. So, and it doesn't need to be money necessarily, although money's addressed here, but any kind of gain or loss, and that could again be, prestige, power, reputation, money, property of some kind, or standing in the community. If there's a gain or a loss in that, would be an interest. E, a justice has served in government employment and in that capacity participated as a judge in a previous judicial position, counsel advisor, so that would be Justice Kagan for sure, or material witness concerning the proceeding, or has expressed during prior government or judicial service an opinion concerning the merits of a particular case and controversy. So I would use the Citizens United case again as an example. So if there's anything that came up in front of her in line with the case that she had already argued, then that would be something she would need to take into consideration. F, the justice's spouse or a person related to the justice or the justice's spouse within the third degree, so 3 steps of relationship, or the spouse of such person is known by the justice, 1, to have served as lead counsel for a party below, or 2, to be an equity partner in a law firm that appears before the court on behalf of a party to the proceeding, and the court has not received written assurances that income from the Supreme Court litigation is permanently excluded from the person's compensation. Yes, I believe it is in effect now. I think as soon as it was put out, it became in effect. It's better. My hand is much better. Thank you. Thanks for asking. So this is important too. So if a spouse or person within 3 degrees is getting, again, some kind of a financial benefit from the Supreme Court litigation, could also be seen as an incident. Substantially affected mean in the previous clause. Do you mean in B down here? Wait, hold on. Substantially affected. Okay, so, or in a party to the proceeding or any other interest that could be affected substantially by the outcome. So, we've got a lot of different ways of looking and seeing what level it could be. We have errors, and then we have harmless errors, and we have substantial errors. So it's a continuum on the least amount of involvement to the most amount of involvement. So substantial would be more than 50%. Yeah, I mean, our language could be, I don't think it could be any more vague. Should be retroactive. Well, I wouldn't argue with that. All right, so that's E, and there's F. So we've got a couple, again, these are just examples of disqualifications, but there could be any other kind of disqualifications as well. They said these were in place and now in writing. Right. And what Chief Justice Roberts had written, so he had written a letter, an official letter to the Judicial Committee at the House of Representatives to Congress, because they said, hey, Chief Justice, could you come and testify about your ethics and how you run your court? And he said, no, I'm not going to do that. But here's a letter explaining that we are above reproach and that we follow our own ethics and that we always have followed our own ethics. And we will continue to do that. It's not exactly the federal court's ethics, but it's similar. It's kind of a hodgepodge of a whole bunch of different stuff. But I'm not going to come in and testify. And so now he's basically saying, fine, we'll tell you what our rules are then, because everybody was so frustrated with it. Yeah. Oh, yeah. I mean, talk about the top of a pyramid. Absolutely. All right. Number 3, the rule of necessity may override the rule of disqualification. Now, of course, thank you. The rule of necessity would mean, of course, if they didn't have enough justices to hear something and it was incredibly important. So if they have to, get off my lawn. If they really need to have the justice and that disqualification comes into play, they'll discuss it and they have to weigh it out. It's a balancing test. Number 4, neither the filing of a brief of amicus curiae or amicus curiae, nor the participation of counsel for the amicus curiae requires a justice's disqualification. So an amicus curiae brief is a friend of the court. This means it's usually an outside party, so someone who is not a party to the case that has specialized knowledge, and they'll write a big, huge brief explaining some issue in the case in order to help judges understand the case better. So, like, for example, in the Bergefell case, which was the same-sex marriage case, there were like over 200 briefs, amicus curiae briefs that were filed from all different kinds of organizations all around to do that. So what they're saying here is just because there's a brief that's been filed with counsel here is not going to disqualify you. What's the minimum number of justices not recused can make a Supreme Court decision? That's a good question. I'm not exactly sure how their numbers shake down exactly, because I've seen all different numbers deciding cases. So that's something I'd have to look into. I don't know the exact number. Yeah, I mean, you don't have to have 9 judges in order to have a decision. But as far as what the minimum is, that I do not know. All right. Justice should keep informed about the justice's personal and fiduciary financial interests and make a reasonable effort to keep informed about the personal financial interests of the justice's spouse and minor children residing in the justice's household. All right. So that's interesting. So they're saying here, not only do you need to know about your own finances, but you need to know about your spouse's finances so that we don't have conflicts. I think that's very important. And any minor children, which, that makes sense. Yeah, this one will hurt. I think so. They won't get to use that excuse like, well, that's my spouse's stuff. I don't have anything to do with it. That excuse no longer works under number 5. 6, for the purposes of this section. So let's talk about that. We've got a few different definitions set out here. The degree of a relationship is calculated according to the civil law system. The following relatives are within the 3rd degree of relationship: parent, child, grandparent, grandchild, great-grandparent, great-grandchild, sister, brother, aunt, uncle, niece, nephew. The listed relatives include whole or half-blood relatives and most step relatives. So this is the same rules that we would use for intestate or in probate. So when it comes to degrees of relationship. Fiduciary includes such relationships as executor, administrator, trustee, and guardian. All right. Financial interest means ownership of a legal or equitable interest, however small, or a relationship as director, advisor, or other active participant in the affairs of a party. Except that pet chicken. All right, I'm taking a tea break after the chicken comment. Just a minute. My goodness, pet chicken. Okay. It's been tea time. Yes. Sometimes I just get so excited about the Supreme Court ethics. Yes, Supreme. Oh my goodness. Why isn't Melania being questioned? I'm not sure. I think everyone who has anything to do with anything is being questioned. So she may very well be being questioned. All right. So except that, 1, ownership in a mutual or common investment fund that holds securities is not a financial interest in such securities unless the judge participates in the management of the fund. Now we're getting into the details of this, and this might have something to do too with John Roberts. I know both Gorsuch and Roberts had some questions regarding how involved they were. 2, an office in an educational, religious, charitable, fraternal, or civic organization is not a financial interest in securities held by the organization. 3, the proprietary interest of a policyholder in a mutual insurance company or a depositor in a mutual savings association or a similar proprietary interest is a financial interest in the organization only if the outcome of the proceeding could substantially affect the value of the interest. I just joined after seeing the bond removal request for Floyd. What? They requested the bond removal? Oh dear. Oh dear. Oh no. Floyd, what are you doing? All right. And then 4, ownership of government securities is a financial interest in the issuer only if the outcome of the proceeding could substantially affect the value of the securities. All right. So those are our different pieces. So hold on, everybody. Let me just pause for a moment here and pull up my poor abused laptop. Oh my gosh. Poor laptop. Let's look and see here. Okay. Let me just double check what is going on out there in the world. Let's see here. Okay. I don't have it yet. So I don't have it on my panic list yet. All right, so I'm not going to panic about it. He's been threatening witnesses on Twitter. No! Oh, no. Should I panic now? What's happening? Come on. All right, let's go straight to Fulton County, shall we? Let's just double check real quick, everybody. One moment, please. This is definitely breaking news. So, oh my gosh. Lloyd, what are you doing? He's in so much trouble already. You would think he would chill out. I guess we always think that, and then it doesn't happen. Okay. All right. Well, interesting, everybody. You saw it too? Okay, interesting. Yeah, it's not pulling up for me. I'll need a little time, I think, to really go through it, but very interesting. Okay. Note to self, pull up Floyd's records here. I was going to mention it, but didn't want to. If oh my gosh, I saw it. Yes, in the AP News article. Really? Okay. Interesting. Yeah, we'll have to, oh my gosh. Yeah. Now, I've checked a couple of my dockets and it's not flagged yet. So I'll have to wait, I think, until it goes through the process before I can pull it up. But announced it 3 hours ago. Okay. Yeah, it's breaking fast. And the dockets, they have a hard time keeping up with it. So, all right. Well, we'll see. We'll see what happens. Yeah, they really are. AP is pretty trustworthy. Absolutely. Absolutely. It's on CNN as well. Okay. Very interesting. Let me check one more. Let me see here. Oh my goodness, this computer just yelled at me. Oh my gosh. All right, let me see here. Okay, so yeah, we've got, let's see. Oh my goodness. Oh, so he's going to be going, okay. Oh, there it is. State's motion to revoke bond concerning defendant Harrison William Prescott Floyd. Yikes. Oh no, Floyd, no. Oh my goodness. Oh my goodness. Oh, wow, everybody. That's a lot. Oh, that's a lot. Okay. Okay. Yeah, that's a lot. Wow, this motion's got pictures in it. What? Sorry, everybody. I'm distracted for a minute. What? Oh my gosh, he did a televised interview. Multiples. Oh my gosh. All right. So, right. So we went through that proceeding consistent with the obligations of the judicial office, except that a justice may attend and speak at an event where the justice's books are a fundraising event if proceeds from the event exceed its costs or justice's interest. Okay, so that's interesting. And serve as an officer, director, trustee, or non-legal advisor of a nonprofit, civic, charitable. Because it seems like their rules can be circular. Gift regulations. These regulations are so specific. They have their own. I can't even finish that sentence, everybody. Sorry. So. Oh my gosh. What? Reasonably estimated costs of travel, food, and lodging reasonably incurred by the justice. And where appropriate to the occasion, court. But now I'm not sure. All right. A justice shifts from engaging in activities described in Canon 4. Okay. So if they're going to, because each one of these people is saying that they agree with the code. So if someone grab Floyd's motion real quick, hot off the printer, a lot of wiggle room. Yeah. Oh my goodness, everybody. This is a lot. Can the spouse of a justice be reimbursed for expenses incurred while planning an insurrection? I don't think that's covered by these rules. I think that's a great question. Some expenses can't be compensated for. I'm not sure that qualifies. Oh my goodness. Okay, everybody. This motion, I was just peeking at it as I had to refill the paper. Too bad it's not retroactive. I agree. We'll see what happens. I mean, again, it's more than nothing, but it's not great. It's not great, everybody. Not great. So here we go, everyone. We got pictures. We got lots of pictures involved here. So is everyone ready? Here we go. The state's motion to revoke the bond concerning defendant Harrison William Prescott Floyd. Really? Yes, yes. I always have milk or something in my tea. I do. I'm a big fan. That reminds me, I should have a little tea. Yes, indeed. Yes, indeed. I owe 5 lollipops. I was wrong about the proper. Okay. Oh, I do like the lollipops. They said, okay, it can be viewed retroactively. Yeah, I mean, it's, yeah, I think, again, it's something, it's something. I'm trying to stay positive, everybody. Stay positive, stay positive. Oh my gosh. Okay. Here we go. All right. So, oh my gosh. Let's take a look at what's going on here. Yes. Let me grab his picture. Sure. Absolutely. Okay. Oh my goodness. Thank you. All right, everybody. Get ready. Here comes the picture. Here's the picture. Oh, yes. Yes. Put a little peppermint schnapps in there. Only if it's allowable. I know, everybody. I know. I'm sorry. I know. Oh my gosh. I know. Covered up. So here's Mr. Floyd right here, okay? Here's Mr. Floyd. He's in some significant trouble, everybody. There are pictures in the motion. There are multiple pictures. So get ready. This is going to be very interesting. Here we go. So I took him away. I got to take him away. The screen cracked. Oh my gosh, that's so funny. All right, here we go. State's motion to revoke bond concerning defendant. Remember, he was the one that was in jail the longest out of anyone. So, state of Georgia here requests the court to enter an order revoking the bond previously granted, and here's why. So we've got the grand jury. I'm going to skip through some of this because I want to get to the pictures here because, pictures. So we've got a grand jury indictment of the Georgia RICO case on August 14th. Yes, I'll have to frame it when this is over. Oh my goodness. Oh my gosh. Okay. On August 29th, a consent bond was entered into. Right. Now, here's what the agreement was, the consent bond again. So let me just put a sticky note on here, everybody. So this is Floyd bond revocation motion. My handwriting is still pretty bad, everyone. I'm working on it. Okay, bond revoke motion. So let's get that up so everyone knows what I'm talking about. I'm going to kind of flip through this a little bit quicker so we can go and analyze the photos. So here's what he had to do. Hopefully it's not curling up too much. All right. So the defendant shall perform no act to intimidate any person known to him or to be a co-defendant or a witness in this case or to otherwise obstruct the administration of justice. Defendant shall not communicate in any way directly or indirectly about the facts of this case. That's what I was talking about with the leaked proffered tapes, everybody. That any directly or indirectly about the facts of the case with any person known to him or her to be a co-defendant in this case except through his or her counsel. The defendant should not communicate in any way directly or indirectly about the facts of the case with any person known to him to be a witness in this case except through counsel. So these are the requirements. I don't know that he understood the assignment. Yikes. Since his release from custody, the defendant has engaged in numerous intentional and flagrant violations of conditions of release ordered by the court. Since November 1st, the defendant has publicly tweeted multiple times from the Twitter in an effort to intimidate co-defendants and witnesses, to communicate directly and indirectly with co-defendants and witnesses, and to otherwise obstruct the administration of justice. The defendant's Twitter account has approximately 25,000 followers who can view his public tweets. All right, let's see what he did. All right, so on November 1st, a defendant tweeted the following to witness Brad Raffensperger and Gabriel Sterling. tagged their Twitter accounts, which constituted the act of intimidation. Now, Brad Raffensperger, everybody knows, has kind of made the news quite a bit. So here's what he wrote. Passing this along to the Georgia Secretary of State and Gabriel Sterling, should they be more concerned about interfering in elections, perjury before Congress, lying to DA Fani Willis, or all of the above? And then replying, get some decent legal advice before you wind up spending 20 years in prison for someone who could care less about your sorry. Oh my gosh. All right, so we had a response. Oh my goodness. On November 6th, defendant participated in a video recorded and widely disseminated interview on a conservative daily podcast. During the interview, the defendant discussed the facts of this case and communicated indirectly to co-defendant and witness Jenna Ellis by discussing her plea deal in violation of conditions of release. Well, I mean, you don't have to lie. I think just discussing it is not allowable. It stated the following. President Trump was underserved by people like her. People who would go to the Oval Office and tell him one thing and then behind his back, they would do another. I'm not a lawyer. Clearly not. I'm not a Harvard JD, but guess who is? Jenna Ellis. Right. She literally, if she truly believed everything that she was saying, she could have defended her own self. She didn't need $250,000 of people's hard-earned money to be raised offline, you know? And it doesn't take $250,000 to accept a plea deal either, or to deny one, okay? So she just showed who she really is. Oh, that's not very nice. Yikes. I wonder how much his attorney's getting paid. I have concerns now. I'm not sure about that. All right, here we go. Let's get into the pictures now. Okay. No direct communication, exactly. Yep. In addition to participating in the above referenced interview on November 6th, the defendant tweeted the following link to the interview to amplify its viewership. Thanks for having me on this place. And Jill and David, exclusive J6 footage, manifesto, give the people what's theirs, enough to blah, 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 Twitter. Okay, so there's his picture. So he's adding that on. His attorney's fees just got doubled. Oh, yeah. All right, so put that out. And now we have another picture. I do like the pictures, everybody. It's nice. On November 7th, so next day, the defendant tweeted the following to witness Brad Raffensperger, Gabriel Sterling, and tagged their Twitter accounts. We want the truth. And then he tagged them here, including the Fulton County DA. He tagged the Fulton County DA. What? Apparently he never heard the phrase, a lawyer who represents themselves has a full... Clearly not. It's accountability time. Unseal the ballots. Wow. So we have here absolute truth. That's such an interesting way of promoting stuff. Fulton County co-defendant speaks about the election crimes. Yeah, you're not supposed to do that. Not supposed to. Not supposed to be doing that, sir. Oh my gosh. All right, here's another one. On November 7th, so the same day, he tweeted the following to witnesses Brad Raffensperger, Gabriel, and tagged their Twitter accounts, which constituted an act intimidating known witnesses and direct communication. Black American Dems want the black Trump guy to tell on the racist white Republicans, but only if it's President Trump, lol. Look, the truth is that the Georgia Secretary of State and this guy are the pieces of this you should be mad at. Make elections fair. Wow, this guy. Okay, and then we have a reply here stating, you're broke and going to waste more money putting forth this election lie. We can't wait to lock you up here in Georgia, as if those 5 days you spent in Fulton jail wasn't enough. Oh, ouch. Wow. He's not very bright. What is he doing? This is ridiculous. This is really ridiculous. Pushing boundaries. Yeah. All right. So the next day, November 8th, defendant tweeted the following to witness Brad Raffensperger. Wow, he's really after Brad, and tagged his Twitter account as an act to intimidate known witnesses or direct communication with a known witness about the facts of the case. So it's over. At Secretary of State needs to call his lawyer. He's about to go through some things. that's kind of, that kind of seems threatening, doesn't it? Senior VP of Customer Operations of Election Systems and Software's company responsible for the Pennsylvania votes flipping says it was a human error. Someone from our team programmed the What? Okay. So that's another piece involved. I'm not sure what this picture is here, but okay. Yeah, Trump's definitely said far worse, but he's more protected. November 13th, the defendant tweeted the following to co-defendant and witness Jenna Ellis and to witness Dan Scavino. Tagged their Twitter accounts, constituted the act to intimidate a known co-defendant and witness and direct communication with a known co-defendant and witness about the facts of the case. So here we go. Wow, at Jenna Ellis, you're a whole mess, girl. So you didn't stop at stealing people's hard-earned money for your defense. You're also lying. Oh, that's not very nice. I guess they don't teach ethics at Harvard Law anymore. Oh, mean. That's not very nice. Give back the money. And then Midas Touch responded. Should I be reading these responses, everybody? I don't know. I don't know here. It does seem over the top. It does. During her proffer session before Georgia prosecutors, Jenna Ellis said Trump aide Dan Scavino told her weeks after the 2020 election that the boss is not going to leave the White House under any circumstances. We are just going to stay in power. Yes. It's evidence. Okay, everybody. All right, so that was the comment back on his tweet. Oh, my gosh. There is quote tweeting them. Okay, right. I'm not the most savvy with the tweets, the tweeters, the Twitter, the twittering. Oh, sorry about that, everybody. The Xing, what's it called these days? Where all these young kids calling it. Oh, right. Oh my gosh. On November 13th, the defendant tweeted the following about co-defendants and witnesses Jenna Ellis and Sidney Powell, which constituted an act to intimidate known co-defendants and witnesses and indirect communication with known co-defendants and witnesses. The twits tweeting, I'm not sure. I don't know what all the whippersnappers are calling it these days. Oh my goodness. All right. In violation of conditions of release. So here's this tweet. There's literally nothing here but name calling and speculation. Leaking Jenna Ellis and Sidney Powell proffer is nothing more than an attempt at tainting the jury pool. Fulton County is corrupt. When is Georgia leadership going to step up? And then we have a picture here of Miss Powell. Egads! It's still Twitter. I will not entertain Elon's weird world. Fair enough. I agree. Whose lawyer leaked it? So we found out that it was Misty. I'm coming back with the picture, everybody. Beware, okay? Here it is. Misty Hampton. She and her attorney leaked it. So he admitted to it during the hearing. I know, I'm sorry, but this is the one. So he said that she believed that everything should be open and apparent. Should be open and transparent to everyone. And he said he couldn't sleep if he didn't tell the judge that he did it. So at this point, the only penalty that's been involved has been that there's a protective order in place right now. Yeah, I'm not, I don't know. She's been pretty quiet throughout all of these proceedings. So gotta bleach your eyebrows. Okay, I'm sorry. Eyeballs. No, the eyeballs. Okay, I've removed it. I'm sorry. Oh no. Okay, so oh my gosh, Sydney. Oh my gosh, that's so funny. Shell for the clock. It's a bad picture. I agree. The cat. All right, that was hilarious. I'll give you that. All right, here we go. November 14th. Defendant tweeted the following about witness Ruby Freeman, which constituted an act to intimidate a known witness and indirect communication with a known witness about the facts of the case in violation of conditions of release. Now, he's charged with intimidation of her. So he went to her again. This is awful. If we are sharing leaking videos today, why would he do this? Like I said from the start, was terrified and wouldn't talk to anyone of this persuasion. Why? Because racism and political terrorism is very real. This is a cover-up and Fulton County is corrupt. So, and then there's a picture. Yikes. All right, approximately 1 hour later, defendant posted a comment that stated, so this begs the question, if she didn't trust white people to help her, what did she say to the black people that offered to help her? I'll wait for you to get your popcorn. This constituted an act to intimidate a known witness and indirect communication with a known witness on the facts of the case, a violation of conditions of release. It's a video. Yeah. So either way, I mean, this is pretty bad for him to go after her when he's charged with going after her to begin with. All right, November 14th, defendant tweeted the following about witness, Ms. Freeman again, constituting an act to intimidate. Yesterday, the Fulton County DA's office leaked proffered videos, and now they're trying to blame my team in order to get a protective order. Look, funny for DA, if I was going to leak something, it wouldn't be Sidney Powell or Jenna Ellis. It would be this. What? Oh, and then there's some audio. No, man, this isn't all be used against him in court. This looks really bad. This looks really bad for Mr. Floyd. Mr. Floyd's in some trouble. The 14th, defendant tweeted the following about the witness, constituted an act to intimidate a known witness and indirect communication with a known witness about the facts of the case. Or I would share that the officers who overheard the whole conversation thought there was a cover-up like this. And then another audio. Fell asleep back now. Yep, I think I may have fallen asleep too, but dang, look at this. We have another 1 minute audio. He was busy, and that's all going to be used against him in court. November 14th, tweeted the following about the witness, which constituted an act to intimidate a known witness. Oh, thank you. So if there's no protective order, here's the 911 call that shows no threats were made. Wow. Ruby Freeman wanted them to come back and tell her what we could do for her. Set up the meeting at the police station, not me. I did nothing wrong. Oh my gosh, this is a 911 call? That's not allowed at all. That kind of evidence is not permitted at all to be shared. Wow, this guy is... Where's his lawyer? Yeah, I don't know. This is some bad business here. Okay, so November 14th, defendant tweeted the following. Okay, November 14th. So again, I mean, this just the last 2 days. He went off his meds. Maybe... Do you see them adding charges? Absolutely. Absolutely, they could add charges. I mean, this is further intimidation. So witness intimidation could be more charges. Absolutely. Constituted an act to intimidate. Why would my team leak Jenna Ellis and proffer videos when there is better stuff? For instance, her job was reconciliation of ballots. She wasn't even supposed to be on a scanner. And so then he's got another 17-second audio clip. Wow. I'm going to, I don't think we need to have necessarily any pictures going on here. So on the 14th, defendant tweeted the following about the witness, which constituted an act to intimidate a known witness and indirect communication with a known witness about the facts of the case. DA Fonnie Willis doesn't want you to know that federal agents knew and approved of the meeting. No threats were mentioned, and the witness was provided options for help at her discretion. Yeah, lawyer inception. Yikes. Now, his lawyer did make a comment. I'm not sure where. I'm not sure if it was to the judge or what. I just remember listening to him, and he made a comment saying, it was to the judge. He said to the judge he wanted the DA to make a statement on the record that Floyd's team did not release the videos because he said all of this made extra work for him. So he did make that comment. And then Judge McAfee was like, well, actually, if you read the rest of her motion, she said that it was a typo. Oh, my goodness. All right. The 14th tweeted the following about the witness. Again, intimidation, indirect communication. I did not set up the meeting at the police station. The witness asked the officers to arrange and facilitate the meeting. We did nothing wrong. Dude, you're not supposed to say that stuff. Advice to Floyd, don't pick up the... Oh, no. No, I almost said, no, Don't put stuff on there that I might read out loud, people. Oh my goodness. Oh my goodness. All right. November 14th, defendant tweeted the following again. So, does this sound like the witness is being pressured? Why would DA Fani Willis want to hide this from the public? So we have another inaudible 34-second clip. So this was here. He's saying, I think there was, I don't know. It looks like it's a screenshot from the building. We've got telephone here, full computer here, keyboard here, and then we're monitoring something. So, Miss Freeman, oh my gosh, yes, I have concerns here. As detailed in paragraphs 13 to 21 above, has been the frequent target of defendant's intimidating communications. In count 31 of the indictment, that he was charged with influencing the witness in violation of Georgia Code. So, as set forth above, since his release from custody, the defendant has engaged in a pattern of intimidation towards known co-defendants and witnesses, direct and indirect communication about the facts of this case. Is this all stuff that his team was given during discovery? I think it was. That's what I was saying. I mean, how would he have the original 911 call? How would he have any of the audio that was involved? Unless he took the audio himself. So yes, I think a lot of that was discovery that was turned over. Yes, so the other side has to give you all of that exculpatory evidence. So that's probably evidence that the DA gave over. Moreover, defendant's actions demonstrate that he poses a significant threat to intimidating witnesses and otherwise obstructing the administration of justice in the future, making him ineligible for bond. Accordingly, the state requests the court enter an order revoking the bond previously granted to the defendant. Respectfully submitted. So would the attorney be in trouble also? I don't think so. I don't think if the attorney gives the evidence to the defendant and the defendant then displays it, no. Because the attorney has an obligation to show it to the defendant. Trust him enough to give him the evidence. Apparently so. Exhibit 1 is the bond order, again, that was set out originally. And then, and signed, and the certificate of service. So there you go. That's a lot, everybody. He did quite a bit of damage in just a few days. So this all had to do with the videos coming out and him being blamed for it. So his retaliation was to make all of these tweets and go after the witness and go after all of the witnesses. That's a lot. Sounds like he's a tad off. All right, I'm going to show the picture again, everybody, so you can see. Yeah, I mean, it's a problem. So remember, it was Floyd and Cuddy who worked together to do the intimidation of the witness. That's the part they were involved in. And then Lee was also involved. So these three are part of that section of the RICO charge. Can he avoid trouble if he says his lawyer never told him to keep it out of the public? I don't think so, because I mean, they made a really good point. There's not any specific piece out there saying that he can't display the evidence, but what's happening is the language he was using when he was sharing the evidence was intimidating to the witnesses and to the co-defendants. So the language he was using was very threatening. So it's the tweets themselves, not necessarily the evidence, that's going to get him into trouble. Yep. Yeah, Cuddy, yeah, that's always been a big question. Oh my gosh. No. Got it. Thanks. Good. Yeah, he's definitely in trouble. I have done both, Jeffrey. I've been a prosecutor and I have also done criminal defense work. So I've done both sides as well as appellate work. So yeah, it's a big question. Oh, not the orange. The orange is out. Oh my gosh. Was he appointees? Was he of one of the court? I don't know. No, his attorneys, Floyd's attorneys. No, those were hired. All these people live in a different version of reality from the rest of us. Oh my gosh, Mad, so true. So true. It really feels that way. It feels like there used to be a time when if someone told you about the alternate reality they lived in, that they would be asked questions like, are you okay? Now that's not really happening. Now they're just going about their daily lives and it's like, what? What happened? What are we doing? I just don't sit for trial, possibly get a new bond. So I'm not sure if they're revoking bond, then it would be very difficult for him to be, he could appeal it. He could ask for it to be reassessed. But if the judge revokes his bond and puts him in jail, he's in jail until the trial. So he's in. Unless he can somehow prove that he should be given another chance and be allowed out again. But once they put him in jail, then he would be in a situation then that it would be smart to demand speedy. I think he's already waived his speedy, but that's the situation where you request speedy is because you're sitting in jail and you want to get that taken care of as soon as possible. He already waived speedy. Yeah, that exactly, Daisy. I think so. I think Judge McAfee had made sure everybody had waived speedy before the pleas were taken for those two cases. Yep. Can he say his Twitter was hacked? Sure. Can you request speedy after waiving it? No. Once you filed it, once he's put it on file, and I think all of them had to go through, and Judge McAfee was pretty clear about it. He made sure to collect all of the waivers, but once you filed it, you can't reinstitute it after that. Now, if you haven't waived it, you can wait as long as you want and then say, okay, I want speedy now. But if you have officially filed a waiver, then you can't. Please take down the photos. Yes. Off he goes. Bye. Oh my gosh. Apparently I like poking him in his head. And there was a deadline too. Yes, there was. Mm-hmm. You can reinstate speedy after waiving in Colorado. Really? Oh, that's interesting. That's very interesting. How soon will the judges say if he goes to jail? Well, that was just filed today. So the judge was in a hearing earlier regarding the protective order for the proffers. So I would assume he would really, you can finish your dinner now. Oh my goodness. Hey, I understand. I totally understand. He's going to want to get this taken care of really quick, especially because so much happened within such a short period of time. It was only a couple of days. So I would imagine first thing tomorrow, he would they would have a hearing if he's going to set a hearing, or he would revoke. I would assume that they would put a hearing into place. Do you ever think you'd be reviewing charges against the cray? No, I didn't. I really didn't. I didn't. No, I didn't. It's just, it's a very interesting situation. It's an odd set of circumstances that I never thought I'd be a part of. Nope. Any news on Rudy? No, I don't have any news as of yet. I don't have any news out of Colorado either. I'm still kind of listening. Has the date been set for the Georgia trial to start? No, not yet. I think it'll be coming soon. We still have a couple of, appeals that they're still taking care of. And so I think they're going to wait for that to come in before he sets particular dates. Although I think he was not very happy today. He was not very happy with what happened with the proffers. What happened in New York? What's Cuddy accused of? So she was part of the witness intimidation. She was involved with the campaign worker intimidation. She was charged along with him, with Floyd. They were charged with the same counts. So, for sure. So, in New York, it sounds like and I know they did. They filed a motion for mistrial. So, he'll flip. Maybe it won't start. Right. So, he filed a motion for a mistrial in the New York case. I'm hesitant to go through it because it's so much bologna sandwiches. I mean, it's a lot. Crazy. I don't know. So he's filed this. I don't know where it's going to go, but that was really what went down today that was so significant. How would you handle Trump knowing? That's tough. It's absolutely horse hockey. That's really tough when you have a client that won't listen to you and continually throws you under the bus and you can't get removed from the case. I mean, that's like worst case scenario. It is. No one likes baloney. Yeah, this one was bad, everybody. This, like, I don't even understand what they're saying. Like, this isn't even language that we use. Like this one in particular, the court's improper co-judging. So they're talking about the clerk. We're referring to her as a clerk. What her official title is, I'm not actually sure. But they're going after her again, and they're using it as a foundation for a motion to dismiss. Like, this isn't a thing. This isn't even a thing. So it's a lot. It's a lot. It's a lot. It's too much. I can't even in good conscience read through it because I think it's a disservice to actually speak the words. It is. There's a lot of insanity involved. Although sometimes I think insanity makes more sense. This is something other than insanity. Yeah, okay, spam. Yeah, I get it. Sorry about that. 50-50 on spam and bologna. Pick your processed meat product. Yeah, I think so too. Must have been absent the day they taught law at law school. Well, I wonder. I mean, co-judging. Come on. Can his lawyers be sanctioned for filing that? I hope so. I get it. They're appealing the gag order. They're appealing the summary judgment order. They're appealing everything they can. This right here, request for a mistrial, this is not appropriate. This whole thing is not appropriate. It's outside of the realm of proper filings. It's all publicity. It's all drama. It has no legal standing. And it's insulting to all of us that work in the legal field, quite frankly. So it's frustrating to see attorneys get away with this. And it's so clear that the attorneys that file this have not been in court very much. Made them file it, maybe, although I don't know. Maybe, I don't know. It's just so clear that these attorneys do not spend much time. I don't know his attorney, and I'm talking about the, what's her name again? Alina. I'm talking about her specifically. Like, I don't know who this person is, but this person here, she does not know. I mean, you just don't do this. I mean, it doesn't matter how desperate you are. You don't go after a judge like this. I mean, this is unethical practice, in my opinion, for whatever my opinion's worth, which is not much, but she's over her head, and you can only fake it for so long in court. You can't fake it till you make it in court. It doesn't work that way in court. You actually have to have facts and evidence. You can't have fake evidence. And that's like the whole reason court exists, so we don't have fake evidence. And this is just, this is a lot. It's a lot. It seems unethical to me. It seems unethical. Thoughts on accountants going to law school? Yes. More accountants in law school, please. Yes. Absolutely. Absolutely. You will be the top of your class if you are an accountant in law school. Absolutely. Because the practice and the hard work you put into becoming an accountant will serve you well in the legal field. It seems that way. It seems unethical to me. I get it. You've got issues with biases. You don't like the gag order. I get it. But when you're coming in and you're singling out a person this way, and you're saying that the judge can't be impartial, because of this. So by co-judging, the entire argument is she's saying he's a puppet to this woman who's sitting next to him. Now, again, I'm not calling her a law clerk because I'm not sure she is a law clerk, but his assistant or whomever it is, she's saying is she's the one doing all of the holdings and all of the rulings, and he's just a puppet. That to me seems incredibly insulting and unethical. They spelled evidence. No. Well, I'm not surprised. At this point, I'm not surprised. There we go. Yeah, there's a lot. Do you have an opinion on Cannon's recent decision in Florida K-State, which may delay Georgia? I'm on the fence. I'm not sure that she, well, I would say Judge Cannon doesn't care at all about what's going on in any of the other cases. I think she's probably completely swamped by her own docket and is very, very absorbed in her own world. So I don't think that what she's doing or saying is intentional regarding other cases. That's my opinion of it. Who rules on this motion? So this motion was filed. Oh, thank you. Look at that. The emperor hands. Let's see. Defendant's memorandum of law in support of motion for a new trial. So they filed it in court here. There's going to be a response coming in from the other side. And it's Judge Engeron. So they're asking Judge Engeron. They're saying to Judge Engeron, you are a puppet of the woman sitting next to you, your clerk or assistant or attorney, whomever it is. I don't want to use the wrong label. And they're saying, so you need to declare this a mistrial. So they're asking the judge that they're insulting to mistrial the case. Yes, I know. Yeah, like, why would you do that? Like, I mean, this isn't a good strategy. So she's setting out all of these reasons why the judge is incorrect. The principal law clerk's partisan activities. So she's going into details about his assistant there and then asking the judge to declare a mistrial. So look at this. She's putting this into the motion, asking this judge for a mistrial. Like, what? What are you doing? I mean, the whole thing is just ludicrous, everybody. It really is. This is just poor, in my opinion. You know, and ethically, I'm not supposed to speak negatively about my profession, but I think for educational purposes, we have to realize when motions are poorly written. I think that's a lot. A waste of time. Yeah, it could be. And I think too that she wants to get it on file. She wants to get this motion for a mistrial on file, and the actual substance of it wasn't that important. Just wasn't that important. What happens when this is over? Get the red pen. No, I couldn't even read this to you in good conscience. I couldn't. It's just bad. This is what you don't want to do. Why are they so fixated on the clerk? It seems like, you know, New York they have their system works a little bit differently. So their assistants, again, and I use that term because I don't know the official name for it. They have assistants, or basically like their right-hand person that helps them in their cases. It's different than other courts. In New York, this is how they do it there. So they're after her because she's, doing her job. Principal law clerks presiding on the bench with him to his right-hand side. And so I think they don't understand how New York court works. I think they don't understand the role of this person who works for this judge, with this judge. And I think because of that, they're blaming her and claiming that she's somehow politically motivated, which is not appropriate whatsoever. Yeah. So, and I'm not sure if anyone on here does any work in the courts in New York. They're technically New York attorneys, but from what I've heard, she has this listed as her office, but it's a shared office space. She's basically a personal secretary. Okay. I mean, she is an attorney. She is licensed. She's been admitted to the bar. Okay. See, and for me, because I don't practice in New York, I don't know exactly what her role is. So, but I know that it's common practice in New York. She's an attorney out of New Jersey. Okay. Sister-in-law's used to... Really? Okay. So, yeah, I mean, this is just one of those things that is historically just part of what they do in New York. Don't they have an obligation to understand the rules of court? They absolutely do, Paula. And I think here they're not figuring that out. Haba's not New York. Yeah, I think she's got probably an office, like post box or something like that. An attorney on her way to being a judge. And that makes sense. I mean, can you imagine if Judge Cannon had been in that position with the judge for 10 years before she became a judge? That might have helped. Might have helped things a little bit. I think it's a good plan. I've got no problem with it, but I recognize it's in a jurisdiction that I don't practice in. And so, for them, it's like, oh, why is she sitting next to him? Well, figure it out. Why don't you understand what the local rules are? Pennsylvania had their staff just not next to the judge. I think it's unique to New York. I really do. I think it is something that is just a special situation in New York. Yeah, all the judges have a side person working on cases with the judge in New York. Right. And, in my jurisdiction, we've got tons of clerks and tons of people that assist the judge too. And there's always someone actually seated to the right of my judges as well. We don't have a specific designation for a title for them, but we would never imply that they somehow were telling the judge what to do at all. Usually it's like a research assistant situation. So Texas clerk sits next to the judge, just a little lower. Yep, exactly. It is unique to New York. Okay. Yeah, that's what I thought. That's what I've heard. Yeah, we all have a little different process. Yeah, hung up on her donations to the Democratic Party, and then also this picture of her with, what was his name? Schmerber or whatever, with this Democratic person. So pictures with that. And so now apparently she's running the trial because she's sitting next to the judge and has made contributions. Schumer. Thanks everybody. Chuck Schumer. Oh my gosh. Sorry about that. Sorry, there was a First Amendment case involving a name like that I was just reading through the other day. So, New York Senator. Okay. Schumer. Okay. Got it. Yeah, so there's a picture of her with him. And so they're using that as the basis for all of this. I think it's time for a yodel break. Oh my gosh, I said too much. We love Chuck. Okay, great. Yeah, I really don't know much about it other than they're using it as a way to say that, she's somehow running the show. But if you've read any of the opinions that this judge has written, this judge is running the show. There's no doubt about it. I mean, it seems it's insulting. It's insulting to this judge who's been on the bench for 20 years. So, have you had any tea recently? I haven't. I need to take a tea break, especially after the Schmerber situation. Oh dear. So that's the update out of New York then, everybody. Not very political. I'm really not, everybody. I'm sorry. I'm truly not. Like, I don't mean to, I don't mean to insult. I'm in my own, world. I'm in my own world. I try to pay attention, but oh my gosh. Yes, tea break. So that's the update then out of New York. So we've got that quick update out of Georgia with Mr. Floyd. We've got the Supreme Court Code of Ethics update. So that's been quite a bit. And then earlier tonight, I did go through the Hunter Biden subpoenas. So I will have those up on my Tube of You channel very soon. Probably the subpoena ones. That's fair to them. Then what's their stance on? Oh my gosh. Excellent point, Amber. Colorado 14th Amendment decision this week. I hope so. I really hope so. And I had posted Michigan had bumped their case. So I do want to go through Michigan's opinion because they take it through the history of Michigan law and set out a couple of pieces a little bit different than the Minnesota case. So I will be going through that tomorrow on a live. That's my plan. So, oh yes, my pleasure. My pleasure, everybody. I think I will go ahead and sign off at this point and get to my yodeling for the evening. But I do plan, I will be back live again tomorrow. I will go through that Michigan decision along with any orders that have come up, any updates. I do like to try to stay on top of it as best as we can. We had a couple of things that did come out in the other cases, but nothing major at all. So I will be back again tomorrow and to go over the information and kind of do a Q&A. So yes, thank you for coming, everybody. And those of you that were with me earlier, thank you for coming back. Always fun to see you. The trolls kept you busy. Oh, my moderators. Oh, you work so hard. I'm so thankful. Everybody, let's give a hand to the moderators. Working hard, working hard. Thank you so much. Knock, knock. Okay, who's there? Yes, we do try to do updates as best as we can. Yes, thank you so much to the moderators. Oh my gosh, so underappreciated, but so thankful for your hard work. Okay, everyone, so have a great night. I will see you then tomorrow, 7 o'clock, and we will do updates and go through that Michigan order. So have a great night, everybody. Yoda Lady Who. Oh my goodness. I'm not going to live that one down, am I? I'm just not going to live it. I'm not going to live it down. Oh dear, I've said too much. Oh my gosh. Okay. Well, good night, everybody. Have a great night. See you all tomorrow.